Hello, and you're in for a great treat today because I'm going to be talking about the 10 most important things you need to know about a power of attorney. Why is this important? Well, as an estate planning and elder law attorney, I get asked all the time what a power of attorney is, or someone refers to a power of attorney in the incorrect context and says things like, oh, geez, I wish I knew that, or gosh, if I had only known. And so the whole goal here is to get this information out to you so that you do know and that you can take that and plan better. So there are things in the legal world, of course, estate planning attorneys in general just know because that's what we deal with every day. That's what we're trained for. And it's easy to lose sight of that sometimes for us when we're talking about the greater community because as people, as humans, we like to use language that's more commonplace. It's colloquial. And we say things like power of attorney without really understanding necessarily what it means. And so for me, when I hear that through that context, I want to help provide more information. So when you say the words power of attorney, you're empowered. You know what they mean. You're educated. Just like if I say something and I'm referring to something medically, my hope is that my doctor will inform me better so I understand. So that's the whole goal here. So today, the 10 most important things that I see that I want you to know about when it comes to a power attorney. So first, essentially, what is it and what it's not? Kind of basic it sounds, but really important because this word gets bantered around a lot. Power of attorney, what it is a permission slip. Basically, is that you're giving somebody else permission to act on your behalf, step in your shoes from a legal perspective, to make decisions for you financially or legally. An example, financial, of course, is being able to go down to the bank and make withdrawals or move money out of accounts, talk to the financial institutions that manage your stock portfolios or your retirement accounts. On the kind of legal obligation side, we have one that most people do or should do every year, which is file tax returns. And you have to sign a document that has some legal resonance to it. And if you can't do that on your own from a standpoint of you're incapacitated, or it's just not convenient at the time, then you can have somebody else sign on your behalf, and it legally works. A contract, maybe you're not in country, you're somewhere else, and somebody needs to sign a contract on your behalf. They need to have the legal permission to do that. So that's what a power of attorney is. It's giving legal permission. What it's not, number one, it's not a will. So it's not a place that you're going to put down who is going to inherit the things in your estate, whether it's money, items. It is not a will. It is also not something that takes power away from you. So if you are giving a permission slip, you're giving someone else permission, but you're not saying you're taking my ability to act for myself away from me. I'm just giving you permission to go act for me. You're my proxy. That means that you can still act for yourself if you had the capacity to do so. And you're just authorizing another person to do that alongside of you. It is not a HIPAA waiver to have a power of attorney, nor is it giving anybody authority to act for you on a medical level, making treatment decisions for you. Now, often I bring this up because oftentimes we hear the phrase medical power of attorney, or there's this thought that a power of attorney is all encompassing. Well, it's not. A typical power of attorney deals with financial and legal obligations. A medical power of attorney, as some states call it that, in California we call it advanced healthcare directive. That is a separate legal document that establishes those permissions to act on your behalf to make medical decisions or caregiving decisions. The ability to get protected health information is carried forward in a HIPAA waiver. Sometimes that HIPAA waiver is nested in a power of attorney document in the language of it. Just kind of depends on who prepares that document, how they create it. Oftentimes, the HIPAA waiver is a separate document. So you really have to be clued into what sort of powers are in the actual power of attorney. So at the end of the day, again, a power of attorney is basically a permission slip saying this person can act for me on my behalf, and these are the ways in which they can act, which goes into the second thing I want to share about power of attorneys, which is there's different types of power of attorneys. There's just not one catch-all power of attorney. As we said, it is relegated to financial and legal obligations, number one. Number two, there's something called a durable power of attorney. So oftentimes you'll hear, well, a durable power of attorney. I want a durable power of attorney. I just don't want a regular power of attorney. And what does it mean, that durability? What does it survive? Well, the durability survives your incapacitation. So if you, when you complete a power of attorney and you sign it and say, I give this other person a permission to act for me, and then later you have a brain injury or you have an onset of dementia and you're declared to be incompetent, or in other legal language we say incapacitated, your power of attorney that you put together before that time is still operable, which means that it's still good. It doesn't get negated because you then have become incapacitated. That's why we call it a durable power of attorney. There's language in that document that says this will be durable even through my incapacity. So, of course, generally, that's a type of power of attorney we want. We're setting it up for people to act for us when we need them to act. And we want the legal permission to still exist even after the life event occurs. Okay, so that's what a durable power of attorney means. Another type is immediate or springing, or a limited, or what I call carte blanche. So immediate power of attorney versus springing power of attorney has to do with the effectiveness. So immediate power of attorney, you're saying, is the people that I'm putting on this form, the names I'm writing down, they can immediately act for me right now. It is not based on my health condition. I'm saying that person can go out and file my taxes. That person can go make financial transactions for me. That's what an immediate is. A springing is saying, well, wait a minute, I'm going to have those people act for me, but only if the following things happen. Generally speaking, it's contingent upon your cognition, your ability for your brain to work. If a doctor declares you to be incompetent, then you say those people can act on my behalf. But in the meantime, while I have a sound mind, well, you know what? I take care of my own affairs. Those people don't have legal permission to do that. Which one's better? It depends. It really depends on the situations, and those are great discussion points to have. But just know that there's two different types. Limited versus carte blanche. Limited is that we're focused on permissions for only certain things. Carte blanche is, oh, why world? We're just going to have a document that allows somebody to act for all purposes. Now, there's not one verse that's better than the other. They're very circumstantial to your needs. An example of a limited power of attorney might be you're giving somebody the authority to fill out documents to purchase a home or sign a contract. That happens a lot in the entertainment industry. An agent has a limited power of attorney to sign a contract for a sponsorship, for any sort of job with the studio or sports team, whatever, but it's very limited. That permission slip doesn't allow that same person, who is called an attorney in fact, by the way, but does not need to be an attorney, more on that in a second, allows that person to only the permission to do the things allowed in the limited powers of that document. So they can't go outside of that and say, I have a limited power of attorney, so that means I can access your bank account. No, you only have the authority to be my proxy to sign this contract. Carte blanche means you're just saying this person could be my proxy for whatever. I have no idea what's going to come up, but I'm going to give them authority to act in any capacity for me to do the things that need to be done. This can be, of course, important. It's not necessarily a bad thing, but one with caution and some things to think about. Do you want that person to have the ability to change any of your estate planning? Like if you have a trust, can that person amend your trust? Things like that. Can that person amend beneficiaries that you've designated in life insurance policies? If you don't like those ideas, then you don't want to completely carte blanche. You want to tailor the powers accordingly. So you want to limit them a little bit. You can have them a little bit more wide-reaching than a limited power of attorney, but perhaps you don't want them so expansive. So those are some different types of power of attorneys. Who you designate as an agent really matters. So doing the HR personnel of your power of attorney is super important. Why? Because who these people are, they're implementers of your life, your financial and legal life, and depending on different situations. Again, you could be alive in a sound mind, but you might not be of sound mind. So you have to choose wisely. These people are called power of attorney agents or attorneys in fact. They don't have to be attorneys, as I mentioned. They don't have to be financial advisors. They don't have to have financial experience. One quality that they need is to be responsible. And because they are going to have legal responsibilities to you, fiduciary duties. These are important legal obligations. And of course, you want somebody that's going to be acting responsibly on your behalf. And responsible, in my mind, means somebody that, of course, is organized, somebody that is capable of asking for help, seeking out help and resources in order to make reasoned, educated decisions, and is, of course, somebody that is dedicated to you. The magic number is two. You can have as many an infinite number of people, but of course, we don't have an infinite number of people whom we know, like, and trust to be responsible over us in such an intimate manner. But we need at least two. Why? Because if typically I see a husband and wife will just name each other. And so I'm reviewing an older estate plan. Oftentimes that's what I see. I see a husband's named wife, wife's named husband, but they have no backups. So what happens when both husband and wife get old and have dementia, or they're both in an accident? And they have nobody that they've given permission to act on their behalf. So we need to have successor or alternate agents. Those are our backups. So you need to at least have two people. One is your primary, one is your backup. Having a third, a fourth, yeah, that's great. And that would be helpful to mitigate the risk of going through one and two. But make sure you're just not naming people to fill up spaces, because again, it comes back to being responsible. And oftentimes I see when people are looking, who do I choose to be an agent? They're looking at their close universe of family and friends, and that's who the pool that they're going to pick from. Not a problem, again, if they meet the core requirement of being responsible. But sometimes, those people don't fit those core requirements, or choosing them might disrupt the harmony in a relationship, whether it's a friend relationship or familial relationship. For example, oftentimes I see parents either have or want to name their children as their attorneys in fact. And the way in which they want to name them is by birth order. Or sometimes they want to get everyone together in a big party and they want to have co-agents. So some things to think about and be aware of in those situations are, is the birth order of your children commensurate with the order of their responsibility or their characteristic of being responsible? Just because they're firstborn doesn't mean they're more responsible. Or just because they are the youngest doesn't mean they're irresponsible. So you got to have to assess a person by their very nature. Also, joining people together, forcing decisions together might not be the best scenario. It might disrupt the harmony that might already exist, or sometimes a very tenuous harmony that exists in families amongst children. And that working together isn't always a good thing. They're not capable of it, or their relationships become strained because there's disagreements. And what happens if people disagree? Decisions can't be carried forward. So if you have 2 or 3 children as co-agents, 1 or 2 of them don't agree, then guess what? Decisions aren't able to be made. And they end up going to court to seek guidance of a judge to break the tie, or they go through litigation because one is trying to remove the other one. So you want to be wary of the issues with co-people. And lastly, consider Switzerland. Switzerland can be your answer here in choosing personnel. What do I mean by that? Switzerland is often known as the neutral state. So looking at neutrality and building that into your power of attorney planning could be important. So you can have a neutral person, neutral to your family, friends, circle, neutral to you. Those are called fiduciaries, and there are individuals called professional fiduciaries. It's a licensed profession. These are people that are professionally executors, trustees, attorneys in fact. And you can go out and select the ones that you like and write those into your planning. There are others that are corporate fiduciaries. So oftentimes these will be trust companies, or they will be part of a bank that has a trust company, like Farmers and Merchant Bank, Wells Fargo, or their larger corporate trustees out there, like Whittier Trust, for example, or Northern Trust. And you can use them, First American. Those are all 3 good examples of corporate trustees. You can designate them as your attorney in fact. The benefit is that of the neutrality. You don't have to maneuver any family dynamics. You prevent any sort of potential arguments within or conflict within the family that that can roll over into expensive and unfortunate litigation because you have a neutral person. And for those people that don't have close relationships anymore, either in their life or oftentimes our older clients, unfortunately, their trusted family and friends have predeceased them. These are good opportunities for them to put people in place that will actually carry forward and take care of them. Otherwise, if you don't have somebody there, then the court will pick one for you. So if a court's going to pick one for you, you might as well go ahead and do that on the front end. At least that's my feeling. So the fourth thing the important thing I want you to know is when your power of attorney is effective is very important. And so we talked about different types, immediate versus springing. Immediate means it's effective right now. Is that what you want? Or not? Springing means it's effective upon a conditioned outcome in the future. Is that what you want? You got to talk about that. So if we're looking at springing, how is springing determined? It's determined based on your capacity or incapacity, to say a different way. Who determines that? Well, generally speaking, you have an evaluator. An evaluator makes an opinion. You have control over who the evaluators are going to be. Is it going to be a doctor? Is it going to be more than one doctor agreeing that you're incapacitated? So do you want that built-in second opinion? It could be a panel of individuals, both doctors and non-doctors, or all non-doctors that you put together, your family and friends have put together. You can have what's called a disability panel. So all of those are options in deciding when it is effective. But this is a very important consideration because there could be situations in which you want your power of attorney agents to act very quickly. But if you have very cumbersome conditions on effectiveness, then they won't be able to act very quickly at all. So you're going to want to think through that and the different scenarios in which you want someone to act. If having a second opinion or having people that know you make decisions about whether or not you have capacity it is important to you, you're going to want to play that through. So everyone is going to be informed differently by the experiences they have in life, but I encourage you to walk through it with a professional who can share with you some actual scenarios that have occurred from both the pros and cons of it so that you can choose wisely. The fifth thing I want to share with you is that you can cancel this at any time. So this isn't set in stone. You create this power of attorney and then you're stuck with it, which unfortunately has been a stumbling block for some to even put it in place because they're worried about the perfection of it. You can change it. So you can have somebody today choose a different one tomorrow. It's as simple as ripping up the old power of attorney and creating a new one. And making sure that those that you have provided the power of attorney for know that there's that one, the old one's ineffective. Really simple, just create a new power of attorney. That's how you change it. Not a problem. Another thing that's important, it dies with you. So a power of attorney is only effective or only valid when you are alive. It does not cover what happens after you pass away. So anything in that document giving anyone authority to act on your behalf goes away when you die. So literally the power of attorney dies with you. You need to have other planning, be it a will, a trust, that dictates what happens after you die. So we're up to 6 now. So the seventh important thing that I want you to know about a power of attorney is you just can't simply go out and get one for somebody. Okay, I hear that a lot. Like, I'm going to go get a power of attorney for my mom or get one for my dad because they're older and we need to be able to step in. And I'm worried about this and that and the other thing happening, and I'm going to go get one for them. It's not something you can do for them. They have to execute the document themselves, meaning they have to understand what the document is saying, and they have to be able to sign the document knowingly and voluntarily. So that requires them to act. Now, of course, you can assist them. You can lead them to the horse to water, but ultimately the horse has to be able to drink. From a standpoint is they want to do that and they can do that. So some of the issues that we run into is that people want to just go get a document and download it online, and they're going to go thrust it in front of mom and dad's face and have them sign, have a notary there. But there can be some real issues with that later, both for the parent and the child that are doing that, because there can be questions about whether mom or dad understood what was going on and were actually making the decisions and knew what they were doing when they were signing that document. And that could unravel some very helpful and important things that could be harmful for mom and dad, such as if they applied for certain benefits. It also can be very problematic for a child that actually facilitated that because it could be viewed as fraud. and they could be challenged by other family members, for example. So when you're going through this, just know that you can't go do this for somebody. You can help get them the resources. Oftentimes we have children are reaching out and calling us, and we're facilitating the meeting with the parents, but ultimately it's the parents that have to have the ability and the desire to go through and sign these documents. The number 8 thing I want you to know is all states recognize a power of attorney, but not all states have the same requirements to make one valid. So it's kind of like all squares are rectangles, but not all rectangles are squares. I think I said that right. But in any event, if you create a valid power of attorney here in California and you are in New Jersey and somebody is trying to use your power of attorney in New Jersey, well, if it was validly created in California, New Jersey's not going to have an issue, not a problem. Even if the way in which California requires a power of attorney to be set up, it differs in New Jersey. It doesn't matter. It was validly created in California. New Jersey follows it, and vice versa. That said, you move to a different state, you got to be aware of when you're doing setting up planning, and this is where some of the problems come in when downloading forms off the internet. Is you have to understand your state's rules. Is a witness required in addition to a notary? Are there certain things that belong in that document in that particular state? Maybe you're used to seeing them in California, but then you move to Arizona or you move to New Jersey, and there's other requirements you're unaware of, and the document you pulled offline doesn't address that. And all of a sudden, when it's too late, you're incapacitated, for example, and you can't make any changes, that document is not viewed as valid. So you're going to want to make sure that you understand your state's rules. Signature dates do matter. So the number 9 thing I want you to know is signature dates matter. What do I mean by that? So the date in which you sign the document is important. Why? Because financial institutions and other places have kind of moved to institute policies that say, look, we're not going to recognize documents that are old. So if you created your estate plan 10 years ago and you have the date in there from 2012 and you did all the other documents along with it, including a power of attorney, there's a strong chance that a financial institution is not going to recognize that. They're going to say, sorry, I know that that's there, the signature's there, the notary block's there, but we have an old date. We have a policy here that anything older than a year and a half or 2 years, we're just not going to recognize. Now, is that founded in the law? Does the law say that when you eclipse a certain amount of years, then the documents become legally stale and ineffective? Absolutely not. But, as I tell clients, there's the law, and then there's what happens in the real world that you have to deal with and your family has to deal with. So your family's going to deal with a situation in which a bank, a financial institution, someone's going to say, you know what, the date on those documents are too old. And then you're going to run into some real problems. So to to subvert that issue, we want to make sure that we're keeping the dates fresh on power of attorney. And every couple of years, we're making sure that we have new dated documents at the bare minimum, even if nothing else changes about the people that you would choose to be your attorney in fact, or the type of power of attorney it is. You're at least creating fresh new documents so your family's not running into those issues. Something to think about. Now, when it comes to healthcare directives, a little bit different. We haven't seen that kind of problem necessarily, except if your healthcare directive is really old and maybe you create it in the 90s or 80s. No joke, I've seen those situations. Then there are likely going to be some problems because many states, California included, have new laws that went into effect since then. And the way in which those healthcare directives or medical power of attorneys were put together may be outdated. Never mind the fact that the the choices you've made in them and directions you put in there may no longer be accurate with your wishes and intentions, but the effectiveness, the validity could fall into question. So you're going to want to keep date signature. And the last thing that I want you to know is that the devil's in the details of these documents. So to simply say, I have a power of attorney, I named people in there to be my attorneys in fact, and I signed it and I kept everything current, like Kevin, you said. Well, there's still one last important thing is what powers are you allowing people to perform for you? What is their authority to act? And it's got to be in that document. If it's not in that document, then it doesn't exist. And a lot of these power of attorneys have like this beginning form where they have a bunch of different letters and little dashes and you initial next to the letters, and you can initial the last one, the letter N, it says all of the above. And when people do that, I think, and maybe even they're advised that, okay, you're covered. You've provided any sort of situation that would ever arise has been covered. But that's not true. And the one biggest thing in there is when it says anything estate related. That initialing that power does not mean that you're initialing allowing or giving permission to an attorney, in fact, to go out and create trusts for you, whether they're revocable, irrevocable, which could be very important and helpful, particularly when it comes to asset protection or pursuing government benefits like Medi-Cal or aid and attendance to the VA. What that means is that they're able to receive inheritances on your behalf. So it's very confusing. So you may want to look into that and have conversations with those people that are helping you prepare. And hopefully you're using an attorney here, not simply downloading a form off the internet, because those forms off the internet are the ones that are going to get you into trouble because you're not going to know what those powers are. And there's ones that are helpful and inclusive, like the ones I just mentioned. Powers that allow your attorney, in fact, to apply for government benefits on your behalf. The ones that allow them to advocate in court on your behalf for purposes of increasing government benefits, to do certain amounts of estate planning on your behalf to help you qualify for benefits. All things that are traditionally not in any of those power of attorneys that you download off the internet. So digital assets is another one. Is your power of attorney giving people permission to have conversations with Apple, with Sony, with any sort of provider of any digital information, whether it's on a website, your email, Google, for example? All that is protected data for you, the subscriber. And if you don't have permissions there to allow that data to be disseminated to people, then they're not going to be able to access it, even if they show up with a kind of a quote unquote regular power of attorney, particularly one that's downloaded off the internet. They're going to hit a brick wall and they're going to be met with lots of resistance. So you have to have a power of attorney that is very specific about these digital assets that are in there, the types and the kinds, so that those that are trying to act on your behalf get information from your cell phone provider, from the company that manages the data on your cell, your computer, your business. They're not met with those problems. So we talked a lot about the power of attorney because there's a lot there and there's just a lot of unknowns. So my hope is with this conversation today is that demystified the whole concept of a power of attorney and really shed light on the fact there's a lot to think about there and how important these conversation about the power of attorney is really, and it shouldn't just be glossed over and say, I'm going to pick, my 3 children, 1, 2, 3 in birth order, or I'm going to choose my spouse and my best friend, and really understanding the impact and the consequences your decisions have and the types of power of attorneys you choose and the powers that you provide. These are all conversations that we have with clients on a daily basis here at Snyder Law, and happy to engage in those conversations with you if you'd like. But at the very least, I hope you learned a lot today, because that's what this is all about, as I mentioned, getting you information out there to pull the curtain back so these things don't seem so scary, and you're making smart decisions. So my name's Kevin Snyder. I'm an estate planning elder law attorney at Snyder Law. Happy to be of help and assistance. And until we talk, continue to be well.